Okay, I'm live. Reading from Criminal Procedure, Chapter 9, Pretrial Release. This is 23 pages. Persons apprehended by police in the expectation that they will be prosecuted are usually provided an opportunity for pretrial release by one of a variety of means, depending upon the circumstances of the offense. If the offense is a very minor one, then release will occur in the field or at the station house upon acceptance of a citation from the officer, which I think they call catch and release. In the cases of more serious misdemeanors, the arrestee can obtain his release once at the police station by posting cash as a security payment in the amount set in a bail schedule, which simply lists the bail amounts for various offenses. Other arrestees must await their first appearance before a judicial officer, when the magistrate will determine the conditions under which the defendant can obtain his release from custody pending the final disposition of the case. Though bail was once limited almost entirely to the posting of cash or a secured bond purchased from a professional bondsman, many jurisdictions now permit the defendant to obtain his release by depositing cash amounting to 10% of the amount of bond set by the magistrate. Sometimes the judge will instead release the defendant on his unsecured promise to appear, or in addition, impose such non-financial conditions as a curfew or reporting periodically to a designated agency in the first Boyle. The term preventive detention is usually used to describe the pretrial detention from a defendant to protect society from the risk of criminal conduct by him pending disposition of the outstanding charges. For many years, this was accomplished sub rosa. The magistrate would set money bail purportedly for the purpose of ensuring the defendant's appearance at trial. The amount would be high enough to prevent defendant's release. But because of reform in bail laws contemporaneously with more direct attention to the questions of whether such pretrial detention is justified, the process of preventive detention is today a much more open one. This is especially true in the federal criminal justice system. The Bail Reform Act of 1984, and on the one hand provides that a judicial officer may not impose a financial condition that results in the pretrial detention of the person, but on the other expressly authorizes judicially ordered pretrial detention of defendants in some circumstances to ensure the safety of any other person or the community. Whether such preventative detention can be squared with the Eighth Amendment provision quoted above is the issue addressed in the other case in this chapter, which is U.S. v. Salerno. So Stack is going to define preventative detention, and then Salerno is going to apply the Eighth Amendment meaning to preventative ends. We'll end the chapter. So we're going to go through it. Stack vs. Boyle, 1951. The Chief Justice Vinson delivered the opinion of the court. Indictments have been returned in the Southern District of California charging the 12 petitioners with conspiring to violate the Smith Act prescribing advocacy to overthrow the government by force. And it was done by indictment. And it involved 12 petitioners. Okay, and so that's kind of the facts or procedural context. So, upon their arrest, bail was fixed for each petitioner in a widely varying amounts of $2,500, $7,500, $75,000, and $100,000. The motion of petitioner Schneiderman following arrest in the Southern District of New York. His bail was hours before his removal to California. On motion of the government to increase bail in the case of other petitioners and after several intermediate procedural steps not material to the issues presented here, bail was fixed at the district court for the Southern District of California in the uniform amount of $50,000 for each petitioner. All right, so that's interesting. Ultimately, that's here we got to. Petitioner moved to reduce bail on the ground that bail is fixed was excessive under the Eighth Amendment. That's the issue. In support of their motion, petitioners submitted statements as to their financial resources, family relations, health, prior criminal records, and other information. The only evidence offered by the government was a certified record showing that 4 persons previously convicted in the Smith Act in the Southern District of New York had forfeited bail. No evidence was produced relating those 4 persons to the petitioners in this case. At a hearing on the motion, petitioners were examined. So this is kind of the evidence and evidence. So this is the state. This is the petitioners. Petitioners' factual statements stand uncontroverted. So, really? So, no evidence was produced relating to the 4 persons to the petitioners in this case. At the hearing on the motion, petitioners were examined by the district judge and cross-examined by an attorney for the government. Petitioners' factual statements stand uncontroverted. After their motion to reduce bail was denied, which I'm going to say is the procedural context where we start, the trial court denied motion to reduce bond. Did I say bond or bail? Bail, whatever. Upon consideration of the record on the motion to reduce bail, the writs were denied. The Court of Appeals for the Ninth Circuit affirmed. This technically is the procedural context. So, from the passage of capital offense shall be admitted to bail. This traditional right to freedom before conviction permits the unhampered preparation of a defense and serves to prevent the infliction of punishment prior to conviction. Unless this right to bail before trial is preserved, the presumption of innocence secured only after centuries of struggle would lose its meaning. The right to release before trial is conditioned upon the accused giving adequate assurance that he will oaths of responsible persons stand as sureties for the accused. The modern practice of requiring a bail bond or the deposit of a sum of money subject to forfeiture serves as additional assurance of the presence of an accused. Bail set at a figure higher than an amount reasonably calculated to fulfill this purpose is excessive, relevant to the purpose of assuring presence of the defendant. So that's a rule, is that it has to be like relative to assuring the presence of that defendant. The traditional standards as expressed in the federal rules of the criminal procedure are to be applied in each case to the defendant. Upon final judgment of conviction, petitioners face imprisonment of not more than 5 years and a fine of not more than $10,000. It is not denied that bail for each petitioner has been fixed in a sum higher than that usually imposed for such offenses with like penalties, and yet there has been no factual showing justify such action in this case. The government asked the courts to depart from the norm by assuming, without the introduction of evidence, that each petitioner is a pawn in a conspiracy and will, in obedience to a superior, flee the jurisdiction. To infer from the fact of indictment alone a need for bail is an unusually high amount is an arbitrary act. Such conduct would inject into our own system of government the very principles of amount greater than that usually fixed for serious charges of crimes is required in the case of any of the petitioners. That is the matter to which evidence should be directed in a hearing so that the constitutional rights of each petitioner may be preserved. In a hearing so that the constitutional rights of each petitioner may be preserved. In the absence of such a showing, we are of the opinion that the fixing of bail before trial in these cases cannot be squared with the statutory and constitutional standards for admission to bail. Accordingly, petitioners may move for reduction of bail in the criminal proceedings so that a hearing may be held for purposes of fixing bail for each petitioner. So ultimately, I'm going to say that they remanded to reduce bond to reasonable amount. And I say bond, but I mean bail. And that's a relatively short and succinct and favorable opinion of Stagg versus Boyle from 1951 on page 638. We're at 12 minutes. There is going to be 11 pages of Salerno, which is why I think I might wait and do another recording after briefing this case.